Hi everyone, this is attorney Minhas. I'm back with another immigration video, and today's topic is going to be about still the adjustment of status for parents of U.S. citizens who are over the age of 21, but this video is just going to have a little twist. So now I know I posted a video about adjustment of status in the United States and what your parents can expect at a USCIS interview, but now I want to talk about if your parent has a case before Eoir, or it's also known as immigration court. So what happens if you have a parent who needs to adjust but can't do it before USCIS and has to do it before the court? So make sure to stay tuned. And again, if this is your first time here, make sure to hit subscribe and hit the bell icon to stay updated about any updates, any informational news that I post on U.S. immigration. And if this is not your first time back, welcome back. Let's check out this video today about handling your adjustment of status before immigration court. So generally, there are about 3 processes that you can pursue if you are filing for your parent and you're over the age of 21 and a U.S. citizen. So the first process is usually adjustment of status if your parent lawfully entered the United States, and that process is done with USCIS. The other process is if your parent is overseas and you file the I-130 petition, and eventually it goes through consular processing. Now there's another one that a lot of people don't really talk about because it's really nerve-wracking, and it's a process that gets taken place before the immigration court. That's also an adjustment of status, but instead of it being before USCIS, it's actually before the immigration court. Now, before I get more into detail about what happens in immigration court and how you can handle the adjustment of status process, I do want to mention that it would be wise to sit down with an immigration attorney to go over the case and make sure that you don't have any issues, and that immigration attorney will be able to guide you and hold your hand through the entire process. So then it could be less hectic and less nerve-wracking. So a lot of times if your parents are in a very different type of process or situation, they may have filed for some other application in the past and somehow they end up in immigration court. But if you can prove that they lawfully entered the United States and now you're 21 years old and a U.S. citizen, then you can typically file the petition for them. But now, since they're in removal proceedings, then you have to see whether the judge would like for them to pursue the adjustment of status before the court, or try to seek termination of the proceedings so they can eventually get their status adjusted before USCIS. Now, I don't really want to get into the procedural part of it because that's where you need to sit down with an immigration attorney to go over in detail, but I do want to give you a general idea of what to expect before the court. So typically, if you go to an immigration court and your parents are eligible to do an adjustment of status because you have an approved I-130, you would let the judge know about that. And of course, after the master hearing is complete, then the judge will typically schedule you for an individual hearing, which is also known as a merits hearing. Before the adjustment of status application is granted by the immigration judge, there is an individual hearing that occurs, which is like a trial. It's also called a merits hearing. And at that hearing, your attorney will prepare you on what type of questions the judge or the trial attorney may ask you. Now, of course, if it's a straightforward adjustment of status, then you would need to know what's inside the application. So when the attorney reviews it with you, you need to make sure that the information that was provided on the application is truthful. And of course, do remember, if you've ever lied or you've hidden the truth or something happened while you were trying to get your visa to come into the United States, that's something that needs to be addressed before you go to trial. You want to make sure that you sit down with your attorney to go over all of the adverse factors. Because if you have a fraud or misrepresentation issue, then you may need to sit down and see if you're eligible for a waiver. So you can't just go ahead and adjust if you have other issues on the matter. So make sure you want to sit down and talk about that. But I'm here to help you today to understand what are the type of questions that, the immigration judge or, the trial attorney may ask you. So they may ask you when you came into the country. How many times have you been in and out of the United States? When did you obtain your visa? After you obtaining your visa, when did you decide that you wanted to stay in the United States? When did that intent eventually change? What happened for so many years? If you've been in this country for a long period of time, what happened? Have you ever filed any other petition? Has someone else ever filed a petition for you? If yes, whatever happened with that? Have you ever lied to an immigration officer or any type of official? So remember, if you ever lied, it doesn't have to be verbal. It can be written too. And again, I do want to mention anything you do to try to come into the United States, if you apply for a visa, if you've been refused a visa and you've disclosed that you've never been refused a visa. These are things that can cause issues because immigration might come out and say, well, you lied. You stated that you were never refused a visa, but according to our records, we see that there is an issue. If you have some type of fraud or misrepresentation, it could be almost anything. And of course, that's something that DHS or OPLA, now they're known as OPLA, may ask you. There's, be very careful of what you post on your social media. If there's any type of issues that come up on your social media and you're talking about something that's now publicly known, that can be used against you while you are in court. So be very careful as to what you post and what you do. If you've been working in this country without authorization, that might also be an issue, and that's something that you want to discuss with an immigration attorney. There might be other issues where you haven't filed your taxes, or you might run into an issue where your intent was all along to come into the United States and just settle here. It was never to try to come into the country and eventually go back. And if that's something that you decided that you wanted to disclose and there's a record of it, that might be a problem. So there could be numerous things they may ask you. They may also ask you that if you filed a petition in the past or an application, was that application fraudulent? Whatever happened to it? The details, the contents in that application, are those truthful? How come you didn't show up to an asylum interview that you filed for and now you eventually ended up in court? So if you do have adverse factors, I do recommend that you go over them with your attorney. But again, if you have a straightforward adjustment of status case where you don't have to worry about any type of misrepresentation or any fraud or any issues that might come up, then it might just be a straightforward case. There'll be general questions. There will be questions about, if the person that's sponsoring you understands that they're responsible for you for, some period of time. Of course, you take a look at the affidavit of support and you see what they're responsible for and they understand that. And, sometimes, just to show that you're a person of good moral character, they might call people in for, as a witness. It all depends on what type of case you have. And do remember that it's not just one type of relief that you might qualify for. So if your case is before the immigration court, you might also be eligible for other relief. And that's something else that you would want to discuss with your immigration attorney so you are well prepared for your trial whenever that may occur. So I just want to say thank you for watching today's video. If you have any questions, you can drop them below. But generally, if your case is an adjustment of status before the court, just sit down with an attorney, see how they can help you, and then you can proceed forward. Generally, the adjustment of status application cases before the court, it might be a process where it may take 5 minutes. I've had, some trials where it literally took 5 or 10 minutes, or there have been cases where they go on for maybe 3 hours or so. So it all depends on the type of case you have. I do want to mention one last thing, that you need to also understand that investing your time into your case ahead of time, like in advance, will be beneficial to you. Waiting till the last minute to submit evidence that is required 15 days before the hearing, that's not recommended. You want to make sure that you're well prepared, you know how to testify, and you're aware of like what your surroundings are, what's there to expect, and then what happens after you do get your adjustment of status granted. So I do have a video up which explains that if you have an adjustment of status that is granted, what happens next. Does a green card just, get mailed to your house or what? No, it doesn't get mailed to your house. So I do want to recommend that you go back and check my video out as to what happens if you are granted adjustment of status before the court and if you're not. So you'll know the do's and don'ts and what happens after if, let's just say, the trial attorney decides to file an appeal and they don't agree with the court giving you this grant of the adjustment of status. So I do want to mention, go back to my videos and check out the one where it mentions what happens after the adjustment of status grant before the court, and I hope it's helpful to you. Thank you for watching today's video, and if you have any questions, you can drop them below, but if it's specific to your case, make sure to set up a consultation so we can discuss it in private. Anything that's specific to your case, I do not recommend using the comment section, but if it's a general question, I'll be happy to answer them. Have a nice day.